Hey everybody, Ross Pitcoff here, and I wanted to talk to you guys briefly about the impact of coronavirus and guarantee provisions and force majeure in commercial leases and contracts. Now, typically speaking, when most of you, whoever has a commercial lease that's looking at this now, you probably signed a personal guarantee, which basically stated that in the event the tenant defaults on its obligations under the lease, the landlord can still enforce the lease against you individually. A dangerous provision, however, a lot of people do it because they want to get those very expensive leases and very expensive locales in the city of New York. Now, what most of your guarantee provisions hopefully also include is what's called the good guy guarantee. And the good guy guarantee basically states that so long as you've made all of your lease payments, so long as you're not in default under your obligations under the lease as a tenant, you individually can provide notice to the landlord, which is typically either a 90-day notice or a 120-day notice. Sometimes it's after a few years of time, etc. But you provide a brief period of notice to the landlord to let them know you intend to vacate the premises and surrender the premises back to the landlord. And on that surrender date, you are no longer responsible for any of the obligations under the lease. Now, a lot of people say, well, that sounds great. And it's true, it is. It's great for the individual. Now, if you're doing this, and presumably the idea is that you're going to exercise this clause because the company is no longer solvent. So if you're entering into bankruptcy, the landlord's going to be happy because they know that they're going to be getting the right to re-enter the premises. And you, of course, will no longer be on the hook personally for the rental amounts due and owing. Right now is an interesting time in history, though, because what we're going to see is a lot of businesses who are taking the position that they no longer want a retail premises. They don't want necessarily to be at a physical location, but maybe they want to move their business online. And so they go ahead and they exercise their right under the good guy guarantee to get out of the lease. But now the issue becomes, can the landlord still go after your company itself? 9 times out of 10, it can. Now, some people may have in their guarantee a release that not only releases the individual, but the tenant gets released as well. Whatever LLC or Inc. is ultimately executed, one of the executionary parties on the underlying lease agreement. In those instances, what you want to do is get yourself out, so exercise your good guy guarantee clause, follow the notice provisions under the lease itself or the riders annexed thereto. And then if the landlord is giving an indication that they're still going to try and recover more funds from you, just try and nip it in the bud immediately. Get a full release of both you and the tenant if you want the tenant, the Inc., or LLC to maintain its business. Go ahead and ensure that you're both in a position to get a full release from the landlord and that way you won't be responsible for anything moving forward.